Israel is at the International Court of Justice Friday, defending its military operation in Gaza. The United Nations top court is holding a third round of hearings on emergency measures requested by South Africa. Now, South Africa wants the court to order a ceasefire in Gaza. Israel told the court on Friday that South Africa's case, quote, makes a mockery of the heinous charge of genocide. And the session was briefly interrupted by a protester as Israel's representative began reading the closing statement. Have a look.
The State of Israel requests the court to reject the request for the modification and indication of provisional measures submitted by the Republic of South Africa.
For more on this story, we're joined by Rosa Freedam. She is a professor of law, conflict, and global development at the University of Reading in England. Thank you so much for taking the time to join us on France 24 today. Now, South Africa has submitted 4 requests for the ICJ to investigate Israel. In this latest one, South Africa says the military incursion in Rafah threatens the very survival of Palestinians in Gaza. How has the court ruled already after previous hearings, and what's at stake in this latest case?
So let's be clear, the rulings of the court so far are on what's called provisional measures. The court has not heard the case about whether or not a genocide is being perpetrated in Gaza by Israel. What happens is that when a court case is brought, it can take years for the International Court of Justice to make a ruling. And so in order to make sure that that case remains relevant, provisional measures might be sought. We could think about this in the way that if I accused you of stealing money from me, a court might freeze your bank account while it decides whether or not you have actually stolen that money in order to make sure that the money doesn't disappear in the meantime. So the court has been asked to make provisional measures in order that Israel will uphold the evidence, make sure evidence isn't tampered with, preserve the evidence so that the court can use that in its determinations. It's also asked previously for Israel to make sure it provides humanitarian aid and facilitates water and sanitation and food and healthcare services in the meantime to prevent needless deaths of civilians and other similar provisional measures. In previous rounds, the court has been asked to rule on a ceasefire, and it has refused to do so, saying that Israel has the right of self-defense and that the court cannot order a ceasefire because that would go against Israel's right of self-defense. In this latest round, the 2 provisional measures being asked for are again a ceasefire and the withdrawal of Israeli troops, and also to ensure unfettered access for humanitarian workers, investigators, and journalists.
Now, why do you think that this panel of judges has stopped short of ordering an end to the military offensive so far? I mean, that's something they could have already done.
Well, really, the International Court of Justice is there to rule about international law. If they were to order a ceasefire now, they would be ruling that the military incursion, the war in Gaza, is unlawful, goes against international law. And they made it very clear in previous hearings that it was not their place. They did not have sufficient evidence to rule that this war was not a war of self-defense. Really, it's for the UN Security Council to make that ruling and to order sanctions or embargoes or no-fly zones if it believes that Israel is acting beyond its legitimate right of self-defense. And so far, we have seen the veto power being exercised at the Security Council to prevent such action being taken. We've seen the UN General Assembly pass many resolutions calling for a ceasefire, but the General Assembly does not have the enforcement powers to back up its non-binding resolutions. So this case is being brought because once again, many countries who are concerned about what's going on in Gaza feel impotent because the Security Council is not taking action.
Right, I wanted to ask you more about that because the ICJ judges, they have broad powers to make all kinds of orders, but that doesn't mean that anything will actually happen because they don't have an enforcement apparatus. For example, a 2022 order by the court demanding that Russia stop the invasion of Ukraine has so far gone nowhere. So what do you think, how do you feel like the real impact or purpose of this case being heard before the court is?
Well, we've seen that Israel has not complied with some of the previous provisional measures, specifically the one, and it was raised by South Africa, about preventing and prosecuting members of its government that may be inciting racial hatred against the Palestinians, and in particular, there are two members, Ben-Gvir and Smotrich. It has not complied with those provisional measures. However, it has provided a report to the court, which the court demands after setting up provisional measures, showing how it is complying with things like humanitarian access and assistance. The biggest deal with the court is that, as you say, there is no enforcement powers. You can't put a state into prison. You can't send the bailiffs round to a country. It's not like national court. But it does carry very significant political weight if a country does not comply with provisional measures. And as we've seen with Russia, it has increasingly become a pariah state, not only because of it failing to comply with the court's measures, but also because of its actions. So there is a huge political push that comes with any provisional measures that are being issued.
Professor Rosa Freedam from the University of Reading, thank you so much for joining and helping us understand this very complicated story. Appreciate your time.
Thank you.